Hey, please, hello. Shiva, I'm paying for listing.
Listing, please give it to the courtmaster.
And
All prayers for listing, please give it to the courtmaster.
May I please, Your Worship? Worship, I beg to mention for adjournment, item 13, my lord.
Adjournment, unless you have given an advance leave, it matters not be adjourned.
My lord, the engaged counsel for the petitioner.
No, whatever be, you should have given it earlier. On Tuesdays and Thursdays, no adjournment without advance notice.
May it please your lordship, with regard to item 11, my lord, LCR has not been received, my lord.
11th.
So, yes, my lord.
Okay,
and just plea of religious persecution is also there. no? Plea of religious persecution is also there.
it is there. Just. Okay, item 11. What is represented? Although by order dated 5/1/2022, the records of the tribunal has been called for. But as per office note dated 8/2/2022, the records have not been received. So accordingly, the registry shall send a reminder to the learned member from a foreigners tribunal number 1, Morigao. Urgently sent the records of case number FT 442 of 2010. Next, the requisition shall be sent by email to the following email address of the Direct Tribunal. The matter is adjourned today. List again on, give a date after 3 weeks. 3 weeks.
Obliged.
Wait, please, Your Lord. Lordship, I beg to mention item 6, Your Lordship. Lordship may not like to take up this matter.
Item 6. List the matter before any other bench without one of us. Yes, Your Lordship.
Leave level. Yeah, Your Lord.
Daily list.
I beg to mention item 12 of daily. list. Kindly adjourn.
No, no adjournment. Without advance notice, no adjournment.
Much. Let me be adjourned, my lord. Item 12.
By check.
Okay.
No, but are they ready to take this plea? Speak to them.
I don't know. I am appearing on behalf of PK Roy. Yes, Lord. I have to.
You have informed it. What says the representative of the prayer made by one party to the camp? Madison did not, this will take after 3 weeks.
Okay.
The same date.
Item 1 with 2 for admission.
Records are with us. Wow, so much. Control Lordship first. After 17/2015 Lordship, I am confusing Lordship. After 17/2015 Lordship,
I'm confusing Lordship. Order, how, item number, application number 233.
29 and 233.
Yes, Lordship, 227 and 246, Lordship. How 246 has come, Lordship? Otherwise, record is here, Lordship. But
Just send it. Just send it. Your query is that why this record has come?
no, Lordship.
Then?
Two cases, Lordship. Lordship has asked, on
For
earlier
two
occasion,
matters,
Lordship.
yes.
246, application number 246 of 2000.
No, we had called for 229 and 233.
Yes, Lordship, as per Lordship's order, both the records has come, Lordship. And Lordship, on the Nurul Haq record, Lordship, there two cases are there, Lordship.
Yeah,
246 of 2000 something, Lordship.
46 and 227.
Yes, Lordship. There, in case how it has come, Lordship, it was,
I will tell you why. Because this page 40, come to page 40 of the registration.
improved order.
Here, all these cases were there, the
Yes,
record has been
Lordship.
sent.
Yes, Lordship. This
Therefore,
year, Lordship. But Lordship, originally case was FT case number 610 2012, Lordship. And that was
no,
after-
what we have not done is that we have not sent the record of serial number 228. This has not been sent. And then the 232, which is serial number 4, they have not sent this to.
no, Lordship, it is there, Lordship. In the record, last part of the record is there. Both the records are there, Lordship.
No, here it is 2, 1 and 2.
Yes, Lordship.
And here also there are 2,
Yes, Lordship.
4 records.
Yes.
Total 6 records are here in this order.
Yes.
One is Lordship 610 2012. It was Lordship, Lordship, by the order dated 7/10/2015. 7/10/2015. It was transferred to,
7/10/2015.
yes, Lordship. Order was transferred to FT Hojai Sankodev Nagar to FT Hojai Lanka. And it was renumbered as Lordship. FT case number 27 of
27/10/2015.
7/10. 7/10/2015.
Yes.
In both the records, same order.
We are not getting you. Please repeat again.
Lordship, original case was Lordship.
FTH 612 of 2012.
Yes, Lordship.
That was,
It was from Hojai Sankodev Nagar. And
yes.
on after that, Lordship, it was transferred to Hojai Lanka.
Yes.
by the order, and after transfer of the reference lordship, it was renumbered as lordship.
227.
Yes, lordship.
Yes.
After that lordship, there is another record lordship,
Yes.
and all the records are analogously hard.
Yes. Correct.
Yes, lordship.
So what is the point you are making?
Yeah, on earlier occasion, lordship has asked to made a query about how 246 of 2000.
Oh, there is a reason for that.
Yes, yes.
You see, you see, the court query was, if I can recollect correctly, I don't know whether I can recollect correctly, but what the issue was, by which order these 4 cases were clubbed together and these 6 cases were
yes,
clubbed and
yes,
taken up together.
Yes,
Because these are 2 independent cases.
yes, like.
And there is no order of analogous hearing. That's, we
Yes,
did not
yes.
find it on the last
Yes,
occasion.
yes, yes,
That's
lordship.
why that query.
So, lordship, one second. I am submitting lordship after 7/10/2015 lordship. Uh, I have some confusion, lordship. I could not.
Achha, you have some confusion.
Yes.
We don't believe, we don't think that there is any confusion. What has happened was, these are all independent cases.
Yes.
After 7/10/2015, the evidence was not filed.
Yes, yes.
And therefore, the tribunal, what they did was, it took up all the matters together and disposed of in one stroke of pen.
Yes, lordship.
But there is no order of analogous hearing.
Yes, yes.
Which is- Without any slip, the is absent today, absent today, absent today. एक दिलाई final order, fixed on final order. এই কেসটো এই record টো হ্যাঁ সেইটো
Order and 227 to the approval again. Order. Order 9. Yes,
yes,
sir.
lord.
2 brothers.
they are members of the same family.
Same family. And here in the record, my lord, one inquiry report, my lord, conducted by the sub-inspector of police border. In the order reflected that Moinul Nurul, whose father name is Miller.
Just a moment. Yeah. It is in fact good for the proceedings that you have tribunals like this. Now, in the first record, 229, please come to 26/6/2015 order. Evidence on affidavit filed without document.
Yes.
Correct. Now you will find in the middle of this record, somewhere in the middle of this first file, there's evidence on affidavit handwritten. No, after that, much after that.
Yes, yes, sir.
You found handwritten evidence. Now 2 or 3 pages of handwritten evidence. After that, you see a typed evidence. You found
Yes,
it?
yes, yes, sir.
DW 1, 2, and 3. These are dated 18/7/2016. Correct. You write you note the names of 3 witnesses. One is the proceedee, the second is Samaruddin, and third is someone I don't remember the name, forgot. There are 3 witnesses. And look at the backside. Huh? No. That is because you don't read the records. Correct. What is the name of third one?
Shahidullah.
Sohidullah. Right. So these are the 3 witnesses.
Yes, sir.
Now come to this, for this, this is 18/7.
Lordship.
There's a ticket also been cut in the top, in the first page of the evidence. Type evidence. Court fee stamps,
18/7 to
18/7. Now look at the order sheet, there is no order of 18/7. Documents come and go in the record as per the whims and fancies of the tribunal.
Yes.
Correct, there is no order sheet.
No.
No order sheet. Now look at the opinion. In the opinion at page 42, opinion paragraph 6. In support of the case, DW1, their uncle, namely Somiruddin, and their mother, Habirun Nessa, is present in court and gave their deposition at DW2 and 3, supporting the Indian nationality. So this 2 and 3 is not there. Artificial intelligence, now the tribunal has manufactured that, DW3. Now come to paragraph 7, last 2 lines, 3 lines, 4 lines. Although though the government Gaungura present before the tribunal, he could not produce any records. The tribunal does not even know what the tribunal is dealing with.
The government Gaugura simply deposed that he knows the office, they are from the own village.
This was the confusion, and therefore we gave it to you on that last occasion. Now it took us some time to go through it because we had to recapitulate what we were looking at. And this is what has happened. And therefore this other record, 220, the other case, 227, we did not go through it because here the other evidence is not even discussed.
Yes, sir.
It has to go back. But there must be someone to look into these records in your department.
Yes, sir.
There must be some rewards also for good performance. We give them out of turn promotion in our judicial system. limited departmental examination, they get an opportunity of promotions.
পাগল হয়ে গেছি।
227 to side হও এবার এবার করার আগে 227 to side হও ইয়াতে বেলেগ আছে ইয়াতে বেলেগ আছে বিপুল নেশা আছে এটা আছে and this Habibun Nessa referred there is DW3 in the records of 227. Huh? Single order going to be. But Mr. A.M. Ahmed, learned counsel for the petitioner, as well as the petitioners, as well as respondents are there. Next para. In the petitioner in WPC 5740 of 2017 is Moinul Haq. And the petitioner in WPC 5746 of 2017 is Nurul Haq. So by filing these two separate writ petitions, the petitioners above named have assailed the common opinion dated 29/6/2017 passed by the learned member, Foreigners Tribunal, Nagaon number 7th at Lanka, in connection with FT/L/case number 229/15 arising out of IM within bracket D bracket close T case number 2259/04 as well as FT/L case number 246/15 arising out of IM within bracket D bracket close T case number 1442/04 by which the said petitioners were declared to be a foreigner of post 25/3/1971, who had illegally entered into the territory of India within bracket Assam after the said date. Next paragraph. In view of the nature of order proposed to be passed, the facts of both the cases have not been referred to for the purpose of maintaining brevity in the order. Next paragraph. It would suffice to mention that as per the impugned opinion dated 29/6/2017, 6 references are stated to have been made by the Superintendent of Police within bracket border, bracket close Hojai, which were registered by the Learned Foreigners Tribunal earlier it was at Hojai, Shankardev Nagar as FT case number 662 of 2012 in respect of Mohammad Moinul Haq, the petitioner in WPC 5740 of 2017 and FT case number 610 of 2012 was registered in respect of Mohammad Nurul Haq, petitioner in WPC 5746 of 2017. First off, in course of time, as per order dated 7/10/2015, all these 6 reference cases were transferred for disposal to the Foreigners Tribunal, Lanka. The Foreigners Tribunal, Nogo number 7, Lanka. And these 2 cases, as referred above, were registered. Next para. On a perusal of the TCR received from the said learned tribunal, it is observed that by order dated 26/6/2015, it has been recorded that the opposite party, i.e. the petitioners, had filed written evidence without document, and another date was fixed for cross-examination of the proceedings. Full stop. Record reveals that on 18/7, the records of FT /L/229/2015 reveals that the said evidence on affidavit filed on 26/6/2015, where in respect of 6 foreigners tribunals proceedings bearing FT case numbers 2061/12, 602/12, 2053/12, 610/12, 660/12, and 657/12. On re-registration of the proceedings before the Foreigners Tribunal, Lanka number 7th at Nogam number 7th at Lanka, the evidence on affidavit by Moinul Haq appearing in the records of FT case number 229 of 2015 is a common evidence in 6 proceedings, being FT/L/229/15, 233/15, 246/15, 227/15, 228/15, and 232/15. The one Somiruddin, Somir SYMIR, next word Uddin, was examined as DW2 in connection with 2 proceedings, being FT/L/233/15 and 229/15. And one Sohid, SHOID, Ullah, was examined as DW3 in the set 2 proceedings of FT/L/233/15 and 229/15. Achha, just say after both of these, comma, etc. Comma, etc. Full stop. However, there is no corresponding order of acceptance of the second set of evidence on affidavit by the said 3 witnesses in the 6 proceedings referred herein before. Specifically, in the order sheet of FT/L/229/15 and FT/L/227/15. However, as per order dated 23/1/2017, the tribunal, in the absence of the government leader, has put certain queries to the said 3 witnesses, which are recorded in the back page of the evidence on affidavit filed on 18/7/2016. Full stop. Next para. In the records of FT/L/227 of 2015, And evidence on affidavit of one Habibun, Habibun, Nasa is available, and she was examined as DW3. The said evidence on affidavit appears to have been filed on 6/3/2017. However, in the corresponding order passed on 6/3/2017, the learned tribunal has recorded in the proceedings of FT case number 227/2015 that the opposite parties are present today, and one Sahid Ullah, a son of late Sikandar Ali, is present today and deposited his statement as DW3. And it is further recorded that the evidence resumed on request. Full stop. In the said record, as per orders dated 28/3/2017, it is recorded that the government Gambura is present and deposited his statement, which is accordingly recorded. The evidence is closed. Full stop. Next, but as stated herein before, the evidence of Gambura is not available in the record of FT case number 227/2015, but it is available in the records of FT case number 229 of the sorry 2 233 of 2015. Full stop. Next paragraph. In paragraph six of the common opinion, the learned tribunal has recorded that in support of the case of the proceedings (DW1 OP, their uncle, namely Mohammed Somir Uddin, and their mother Habibun Nasa were present in the court and gave their deposition as DW2 and 3. First off, in paragraph 7 of this said common opinion, there is a reference to the presence of the government Gambura before the tribunal. However, reference to his deposition is recorded without referring to the said witness as DW4. Next paragraph, it may also be stated that in paragraph 5 of the common opinion, it has been recorded that in due course, the OPs within bracket, thereby meaning 6 proceedings, bracket closed, has also filed their evidence in chief as DWs and produced and exhibited various documents. Full stop. With the able assistance of the learned standing counsel for the FT and border matters, comma, the records were thoroughly examined, but the evidence in chief of all these 6 proceedings are not to be found. Most of the common evidence by Mohammed Nurul Haq as DW1 is found in the records. No, not Nurul Haq, it is Moinul Haq is found in the records relating to the proceedings of FT within bracket, oblique L, oblique 229, oblique 2015. Next para. It is surprising to note that there's no order in the records of FT case number 229 oblique 2015, comma, FT case number 233 of 2015, comma, FT case number 227 of 2015, and FT case number 246 of 2015, comma, which are available, comma, any order to club all these 4 proceedings and to take up the in total there's 6 numbers of proceedings together. Therefore, comma, the procedure adopted by the learned tribunal to club the 4 cases without any order and to have the proceedings file a common evidence on affidavit by Nurul Haq. It's Nurul Haq, Nurul Haq. Huh? Common evidence. Moinul Haq, Moinul Haq. This is Moinul Haq. Who don't amount to giving of a fair opportunity to all these 6 proceedings to give their evidence in the proceedings which relates to the issue of their citizenship. Next para. 23/1/2017, as referred above. The tribunal has put certain queries to the witnesses. However, in paragraph 9 of the impugned opinion, the queries put by the learned tribunal have been appreciated as if they were cross-examined. Stop. It has been stated as follows: inverted dash, inverted commas. The OPs in their cross deposed that their mother's name has give a dot dot dot, inverted comma closed. Full stop. Therefore, comma, in the event, not in the event, full stop. Next para. In the said aspect, comma, the court is of the considered opinion that once a tribunal proposes to put queries to the witnesses, comma, it partakes a character of an examination under as envisaged under section 165 of the Evidence Act. Full stop. Thereafter, comma, to treat the queries of the tribunal as cross-examination would indicate that the tribunal, comma, by cross-examining witnesses, comma, has donned DWNED, donned the character of counsel for the other side, comma, which is not permissible or envisaged under any law for the timing in force. So the tribunal was not a prosecutor against the petitioners, and therefore the tribunal could not have cross-examined the witnesses produced by the petitioners. However, the tribunal would definitely have a right to put questions in the in the examination of witnesses as envisaged under section 165 of the Evidence Act, 1872, corresponding to section 168 of the Bharatiya Sakshya Adhiniyam, 2023. Next one. Therefore, the manner in which the proceedings were taken up by the learned tribunal cannot be given an imprimatur of the court, and therefore the manner in which the proceedings was taken up is found to have vitiated the common opinion dated 29/6/2017, passed by so and so in so and so, page 41 of 5740. I put a flag. It will be 40, page 40. Comma, insofar as the proceedings of FT oblique L oblique case number 229 oblique 2015 dash Mohammed Moinul Haq, comma, and FT oblique L oblique case number 233 oblique 15, give a dash Mohammed Moinul Haq is not found sustainable, and that part of the opinion is hereby set aside. Next para, resultantly, comma, the proceedings of FT oblique L oblique case number 229 oblique 2015 and FT oblique L oblique case number 233 of 2015 are remanded back to the learned member, comma, Foreigners Tribunal, comma, Nagaon number 7th at Lanka for a fresh adjudication from the stage of filing of evidence on affidavit by the proceedings of the petitioners in those cases. The proceedings in those cases, i.e. petitioners hearing. Next para. The registry shall send back the records expeditiously. Next para. The petitioners, comma, being Moinul Haq in WPC 5740 of 2017 and Nurul Haq in WPC 5746 of 2017 are directed to appear before the said learned tribunal within a outer limit of 30 days from the date of this order, comma, which is not later you see 1 month, not later than 15/9/2025, and shall submit the evidence on affidavit of such witnesses as they may be so advised. Full stop. Next para. Further clarified that if that as this is an old matter, comma, in the event the petitioners pray for short accommodation, comma, the same shall be granted. A reasonable adjournment may be granted. First of, however, the said learned tribunal shall make an endeavor to dispose of the proceedings within a period of preferably within a period of 3 months from the date of appearance of the petitioners. Subject to the convenience of the said learned tribunal. Next para, it is expected that the said learned tribunal shall take up the proceedings of the two petitioners separately and maintain separate records of both the proceedings. Next para. In, actually, this, we said that records to be sent back. Just mention there, it may be stated that a total of 4 records in 2 files have been sent to this court relating to, on the first of the first record is of FT case number 229 and oblique 15 and 233 of 2015. And the second file relates to FT case number 227 of 2015 and 246 of 2015. So both the records, both the files together with 4 records as referred above are being, they shall be returned expeditiously. Allowed to the extent as indicated above. There shall be no interest to cost. Direct close. Disposed of. Partly allowed. Partly allowed to the extent as indicated above. Partly allowed to the extent as indicated above. Just, and because we have said that we are returning it. So therefore, unless you give it to us, we can't return. That's why we made that mention. 4 records, we have mentioned specifically that we are returning it. Yes.
Miller. Item number 8
Yes.
may not be taken today, Miller.
No adjournment.
Miller, actually, what happened,
we'll-
Miller? I could not charge the file, Miller.
No, you see, touching the file doesn't take much time.
Yes.
You have seen us handling the
Yes.
records. How much time did we take?
No, Miller, this is the earlier not taken time.
We understand, but tell us how much time we took to see both the records. 5 minutes?
Actually, could not charge out the file, Miller, till that time. And
Oh, You see,
I have spent the time in this case, Miller.
you
for the
see,
cases.
we have hardly met any very able and successful counsel who touch the file and they argue.
Fabulous.
It must be here.
Fabulous.
You'll see when it reaches, ask someone to make a mention
Yes.
because we are not adjourning.
Yes, yes. Fabulous.
Supplementary item 18 for admission.
May it to the Lord, but there was a report called upon. Because the reference and the LVO are two
Oh,
different.
acha, yes. I remember. It came up yesterday.
Mara-
That matter.
Mara.
Okay.
মুখে দিবা নাকি? Okay. কি লেখা আছে? No, it's not.
PRO report is available and I have a case, MPO report is available. But concern of is that 40% are different. And 40 days, so this one, online data collection, 40. Both the person names are there, not 16. One, however, suppose wife of Hamid Ali Lottery, it don't tell some that part.
Very good. Even. Yeah.
Serial number 189 is 189.
No, we understand, but the authority is saying, if you have understood this correctly, that Sabira Begum, wife of Abbas Ali, which is mentioned in the electoral registration officer report at annexure 21, is the same person. Correct. So the person, the petitioner is in the electoral registration officer report. Next line says, but Sahira Begum, wife of Amir Ali, mentioned in LVO report, is not the petitioner. So then it has to be fresh inquiry. There's no other option. Even if we examine these things, it is for the authorities to make that examination in the statutory jurisdiction. We'll not be able to say anything more. No, there's, it appears that there is a mistake in the LVOs. Reference was for somebody else. He went to somebody else and then made an inquiry. It has to be fresh. If the Superintendent of Police border deems it appropriate, he will order for a fresh inquiry if required. Hmm?
Nothing
You want to
say
argue?
about-
No.
No. But your lordship has to write hard Mr. P.K. Rajchandani. But I have not said anything.
But that would be false. You don't want the court to record anything false. We say you are present.
But my lord, what I will say that I will go by the bench what I said, my lord.
You must enter politics. You must enter politics. Heard. Mr. P.K. Roychowdhury, the counsel for the petitioner. Also heard so-and-so for the respondents. Next para. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 10/6/2025, passed by the learned member Foreigners Tribunal number 4th, Kamrup Metro Guwahati, in FT space DVK space case number 7/2024, thereby rejecting a petition filed by the petitioner under order 14 Rule 2 of the CPC. for framing a preliminary issue relating to jurisdiction of the tribunal to proceed against the petitioner on the ground that there was no inquiry by the local verification officer in respect of the petitioner. Next para. Sorry, having read this prayer, we find that there's already an ex parte order against you.
My lord, already an expert order.
Yes.
That was subsequently set aside. My friend says that.
No, you see, page 59, paragraph 2. You receive the notice, then last line, last word is the petitioner got information that by an ex parte order dated 13, petitioner declares foreigner.
No.
Then
My friend says that that was set aside by.
where is that?
Court's order.
In page 60, you have written that we have not found that order.
My lord.
Page 60, that same paragraph 2, you have stated that the
The
petitioner
liability
submitted
was set
petition.
aside the ex parte order finding it
But
matter.
you're not getting that order. Is it
That-
available?
EPL the term. But statement is that, but the order is not with my friend, my lord. That page 60, last line, it has said that. Then if your lordship may do one thing, my lord, lordship may fix it for another day. In the meantime.
No, once the report has come, we don't want to do it. Is there any such statement in the writ petition? Please find it out.
Yes, sir.
Oh, yes, it is there, paragraph 10.
Yeah.
Okay. Next paragraph. In this writ petition, a statement has been made to the effect that the notice of the proceedings was hanged in a wall of a shop which is situated some distance away from the house of the petitioner. And petitioner came to know about the said notice on 5/1/2025. So however, by then, an ex parte opinion dated 30/12/2024 was already passed against the petitioner. And accordingly, it is, no, full stop, it is stated that thereafter the petitioner had submitted a petition for setting aside the ex parte opinion, which was set aside, and the matter was fixed for filing of written statement. Full stop. At that stage, the application under Order 14 Rule 2 of the CPC was filed. Next paragraph. Pursuant to such projection made in this writ petition, this court by an order dated 29/7/2015, oh sorry, 25/6/2025, comma, the Deputy Commissioner of Police within bracket border, comma, Kamrup Metro, comma, Guwahati, comma, was directed to conduct an inquiry as to whether the suspected proceedee, namely Sahera, Sahera, Sahera Begum, comma, wife of Amir Ali, within bracket, annexure 20, comma, page 54 of the writ petition, bracket closed, and the petitioner, comma, Sabera, Sabera, Sabera Begum, Begam, wife of Abbas Ali, comma, whose electoral photo identity card is at annexure 16, comma, page 48 of the writ petition, are the same person. Full stop. Next, the learned standing counsel for the FT and border matters has produced a copy of letter under memo dated 23/7/2025, comma, issued by the Deputy Commissioner of Police within bracket border, bracket close, Guwahati, which discloses that after due inquiry and considering 18 documents produced by the were collected during inquiry, comma, arrived at the conclusion that the petitioner, namely, we observe as follows, this para, page 3. Next para. Under such circumstances, as the competent authority, comma, on examination of materials available and produced before it, comma, has arrived at the conclusion that Sabera Begum, comma, wife of Abbas Ali of village Katabari, last para, comma, the petitioner has been able to make out a case for interference with the order dated 10/6/2025, passed by so-and-so and so-and-so, next para, in view of the dispute with regard to the identity of the person against whom reference was made and the person against whom the LBO made an inquiry, comma, the court is inclined to restore the petition number 46/2025, comma, arising out of application number 66/2025 to the file of the learned member, comma, Foreigners Tribunal, Number 4th, Kamrup Metro Guwahati. Next, the the learned counsel for the petitioner has submitted that the next date of the proceedings is fixed on
Tomorrow is the
tomorrow is fixed on 14, huh?
sorry, Tuesday.
Tuesday,
19.
19, okay. On 19/8/2025. First off, on the said date, the petitioner, by producing a certified copy of this order before the said learned tribunal, shall await further instructions from the said learned tribunal. The instructions of the orders, the said learned tribunal. So,
Obviously.
the petition stands allowed to the extent as indicated above.
Yes.
Item 3 for hearing.
Yes,
This matter may also be adjourned.
this matter. You have spoken to Mr. Rashid.
Yes, yes.
Okay. You had a talk? Okay. Both sides are represented. On the prayer made by Mr. A. Rashid, learned counsel of the petitioner. Matters is adjourned today. List, give the same date after 3 weeks.
Yes.
All these matters we are fixing on the same date.
Yes, no. No.
Item 4 for hearing.
May I please, Lordships. My lords, may I kindly see impugn order page 22. And here, the learned tribunal framed through points for decision that may be seen page 25, bottom.
Yes.
Page 25, bottom. Points for decision. In this reference, the points for decision shall be whether the proceedee Sabura Khatun is the daughter of Abdul Sabur. Number two, if so, whether Abdul Sabur is a citizen of India. Now, the discussion has been made in page 26. Top para 2. To prove the case of the proceedee furnished the evidence of three DWs, including the proceedee herself, and also furnished 14 number of documents, which are marked as Exhibit A to N, along with extra copy of the voter list as annexures. Out of these documents, Exhibit H is the original copy of certificate issued by Secretary 51 number Bolodbari Chor GP in the name of Sabura Khatun, daughter of Abdul Sabur of village Hila Pakhiri in the district of Gwalpara, Assam. As per the certificate, Sabura Khatun married to one Quddus Ali, son of Asiruddin of village Bora Kalia, Noshkora. The contents of the said document are proved by the examination of issuing authority that Exhibit H and the deposition of DW2, the father of the proceedee, clearly establishes the link of the proceedee with her father, and it is crystal clear that the proceedee is the daughter of Abdul Sabur. So this issue is decided in affirmative. So here, the learned tribunal has believed that Abdul Sabur is my father. It is decided in my favor. So for the second point is concerned, now kindly see page 26 bottom. That the oral evidence of proceedee and all the DWs are strictly scrutinized, and it is found that the statements of the witnesses cannot be relied to establish the link of the proceedee with her projected grandfather, as there is no documentary evidence. It is made very specific that merely having only father's name of the proceedee being matching with some records does not make the proceedee entitled to get benefit of such records. Those same similar name may be there. In order to have claimed the relief on the basis of such documents, the proceedee must prove the linkage thereof with the oral deposition of the documentary evidence of some other reliable witnesses who may be material to her in support of her claim of being an Indian national. So the issue number 2 is decided in negative. Now I am drawing your lordship's attention that the oral evidence of the proceedee and all the details strictly scrutinized. It is found that the statements of witness cannot be relied to establish the link of the proceedee with her projected grandfather, as there is no documentary evidence. So now let us see whether documentary evidence is there or not. Kindly see page 22, page 28.
Yes,
And now kindly see page 28.
yes,
Here, Akhiruddin Sheikh, he is my grandfather. Then Lordship may kindly see page 32. In between, there are the names of Akhir Sarkar, Akhiruddin is there, who is my grandfather. There are some differences in names. Page 32, here Abdul Sabur, who is my father, son of Akhir Sarkar. Now, in the page 28, Lordship would see village 243 number Monirchal, page 28. Village 243 Monirchal, part 1, post office Patakata. Now, here page 32, Abdul Sabur, who is my father, the same address. Village name number 243 Monirchal. This Abdul Sabur is my father. Then, Lordship may kindly see page 34. Here, Abdul Sabur, A Sabur is there. Village, the same, 243 number Monirchal. And Abdul Sabur, son of Amiruddin. Amiruddin, Amir Sarkar, Amiruddin, these names are there. And Sahara Khatun, my mother, her name is everywhere there. In page 32 also, Sahara Khatun, wife of Abdul Sabur. So that is there. Now, Abdul Sabur has thus linkage with Akhir Sarkar, alias Akhiruddin Sheikh. Page 36, similarly, Sabur Mia, Akhir Sarkar. Sahara Bibi, Sabur Mia, that means my father and mother. Similarly, page 38 also, Abdul Sabur Akhir, Sahara Khatun, Sabur Mia. Page 38.
yes,
Then page 40 also, this is continuous voter list of coming from, it is 1997. Same village, 244 Monirchal, part 2. Sometimes number are changed. Earlier there 243, Monirchal is there. So here Abdul Sabur, serial number 4, son of Akhiruddin, Sahara Khatun, wife of Abdul Sabur. Similarly, this is the voter list of 2005, 42, page 42. Abdul Sabur, Akhir Sarkar, Sahara Bibi, Abdul Sabur. And village name is Monirchal. Now kindly see page 44. This is the Panchayat certificate. I am reading. This is to certify that Srimati Sabura Khatun, daughter of Abdul Sabur, or Srimati Sahara Khatun Bibi of Hilapakri village, 51 number Borodmari Chor, Gao Panchayat, under Matia Revenue Circle of Gwalior district of Assam, who is aged about 38 years, was a resident within the jurisdiction of the said Gao Panchayat area. Srimati Sabura Khatun got married on 12/1/1991 to Sri Quddus Ali, son of Asruddin, and Srimati Kulsum Bibi, mother, who are residents of Bora Kalia, Noskora, village, Gao Panchayat, ward number, so under South Shalmara, Revenue Circle of Dhubri, district, Assam. Sabura Khatun has now migrated from the said Gao Panchayat area to the above mentioned location by virtue of her marriage, which was solemnized as aforesaid. This certificate is issued based on the evidence placed before me. So this is the Panchayat certificate. and the issuing authority of this Panchayat certificate, he has adduced evidence. His evidence may be seen page 86. My name is Amjad Hussain. Address so and so. I have received the notice and appeared accordingly before the tribunal. I have brought the original copy of issue register along with counter file. Exhibit W is the certificate issued by me. Exhibit W1 is my signature. Exhibit W2 is the counter signature of BDO Matia. The certificate was issued in the name of Sabura Khatun, wife of Kuddus Ali, village Borkolia, PS South Shalmara, district then Dhubri, now Atsingimari. The name of father of Sabura Khatun is Abdul Sabur and mother Sahara Khatun Bibi, village Selapakri, PS Mornoi, district Gwalpara. It is crossed. The certificate is issued for NRC updation. The certificate is issued on the basis of application submitted by the father of the proceeding on dated nil. So this person has issued certificate. It is a NRC, it is said the certificate issued for NRC updation. NRC updation or anything, but it proves that Abdul Sabur is my father and Abdul Sabur's father is Akhir Sarkar or Akhir. So the finding of the learned court, learned tribunal, that issue number, point number 2 is where he said that, that is page 26, again I am reading for after discussing these matters, page 26 bottom, that the oral evidence of proceeding and all the details are strictly scrutinized, and it is found that the statements of the witness cannot be relied to establish the link of the proceeding with her projected grandfather. Well, projected grandfather, my grandfather's name is in the voter list of 1966, and that I will come. Thereafter, in 70, my grandfather's name is there. In 71, my father's name is there with my grandfather. And the Panchayat issues certificate that I am the daughter of Abdul Sabur. And the issuing authority has testified. So, how the learned tribunal came to the position that no link projected grandfather, there is no documented evidence. These are the documents. Now, most important thing, another thing, kindly see page now, page 89. This is another proceeding, Union of India versus Jamiron Nessa. Jamiron Nessa is my sister. And there was a foreigner's case against Jamiron Nessa. And in page 94 now, kindly see. '94. '94 bottom. In view of the above discussion and the reasons stated, and also on the basis of documents submitted by the respondent, I have to come to the conclusion that respondent has able to discharge her burden under Section 9 of the Foreigners Act 1946 in proving that she is not an illegal migrant. So the reference is answered into negative and against the state, declaring Muhammad Jamiron Nessa, wife of Wasir Ali of village Borapahar, PS Gwalpara district, Gwalpara, Assam, is not an illegal migrant or foreigner. Now they have changed their address. Now this Jamiron Nessa Whether she is my sister or not, that lordship may kindly see page 57. This is my WS. Page 57, operative portion may be seen. Page 58, para 11. Operative portion, page 58, para 11. That the parents of the opposite party has 7 children, such as Sabia Bibi, Sobura Khatun, that is I, myself, Sobura Khatun, and Jamiron Nessa. That means who has been declared as an Indian citizen, not an illegal migrant. So in my WS, her name is there. Now let us see some voter list. Page 28. Page 28. This is Akhiruddin Sheikh, that is Akhir Sarkar, my grandfather. Page 28, voter list of 1966. Village Monirso.
Yes.
Then 1970 voter list, page 30. Akhiruddin Sheikh, that is my grandfather, who is my grandfather. It is also Monirso. Now 71, here for the first time my name comes. Abdul Sabur, father, age 25, not so much. So Abdul Sabur Akesh Sarkar. So the tribunal, learned tribunal says that the proceeding could not establish that she has the due linkage with Akhir Sarkar or Akhiruddin. That is not correct. At that time in the year 66, my father was not a competent voter. In 70, his name did not appear, though he was competent to be enlisted as voter. But 71, his name is there. So in my humble opinion, well, it is a very good case. The finding of the learned tribunal that not believable, not trustworthy, which may be seen as page 24, page 27, page 27, para 7, 8, and 9. Para 7 is, I have analyzed the entire evidence of the proceeding and the documents accompanying therewith, and also perused the materials available on record. The statements made in the evidence of the proceeding pertaining to the documents of the proceeding exhibited therewith have therefore not been affirmed at all as required, and thus and are of no evidentiary relevance. So this finding is not based on document. The set of documentary evidence produced by the proceeding would demonstrate are laden with gross discrepancies and inconsistency. Discrepancy of name is there, but Monisar is everywhere there. Inconsistency is that names are a little difference. So these are common in such type of cases. Lordship is aware about this. Rendering the same untrustworthy, how the documents can be untrustworthy and unbelievable. All the above indicates only the falsity of claim of the proceeding, as she has not come with clean hand. How? The learned tribunal found the first point in my favor, but second point he comes that not come with clean hands, whereas my father's name is with my grandfather's name. Clean hand, and she fails to prove any vital document to prove that her father, Abdul Sabir, was a resident of India. Why not? Abdul Sabir is a resident of Monisar. My grandfather is also a resident of Monisar. So, my father is the son of a person whose name appears in the voter list 66 and 70, and my father's name appears in the voter list of 71. And Panchayat president says, Panchayat authority says that she has been married to so-and-so places and she is the daughter of Abdul Sabur. So, para 8, the evidence of proceeding coupled with above mentioned documents relied upon by her appears to be not trustworthy, and there is no reason to believe the proceeding. So, these are not supported with any document. Documents say something and the learned tribunal explains the matter in another manner. So, my submission is that the finding of the learned tribunal should be set aside and I should be declared as Indian or not an illegal migrant. That is my submission. Obliged. Well, almost all these documents are exhibited. 66 voter list, that is exhibit A, 70 is not exhibited, 71 exhibit B, 77 exhibit C, 85 exhibit D. So these are all exhibits, major exhibits are there. The Panchayat certificate is also exhibited. Elector photo identity card, that is exhibit K. So the Panchayat certificate, that is exhibit H, who has adduced evidence also. So these are exhibited to public documents, and the private document is Panchayat secretary, that was countersigned by video, and the authority, issuing authority, has adduced evidence. So there is nothing to be disbelieved. I do not believe this. That is not the law. Why you are not believing? Because when you are not believing the documents, how the person would prove their nationality? Obliged.
No.
But your lordship, can you see the voter list of 1966 now? At least 31. No, is 29. This is the executive voter list of 1966. 29. Is filling this voter list, is claiming this the serial number 1 of page 29. This Amiruddin Sheikh, son of Alimuddin, is it about 70 years is the grandfather. Now, who is the voter? Who is the listed voter in this voter list? One Faizuddin Sheikh, Nurjan Bibi, Tafizuddin Sheikh, Rahimon Bibi, Mofizuddin Sheikh. They are the voter here. All are related to Amiruddin. Now, 70 voter list, they did an next month. 71 voter list, madam, you will find at page 33. This is voter list of 1971, but this is not the original voter list. This is a supplementary voter list prepared. This is a supplementary voter list because in the page 33. And it,
Of page 31, what do you say?
31 is not exhibited document.
Not exhibited.
Yes, 31 not exhibited.
66 is exhibited.
Page 29 is exhibited. 31 is not exhibited.
Where do you say it is supplementary?
Page 33, madam.
33.
In the left column, it is in Assamese, upor inchi, madam. Upor inchi. Left side. It's written as
Hi.
upor inchi. Yes.
That's handwritten.
Yes, handwritten. In fact, they have also in their WH additional list.
Islam is not there.
Yes, my lord.
Islam is not there.
Yes, Islamic here. I photos asked to ask him to, my lord, get the instruction with regard to this matter. Please touch it with him.
My lord, eh, actually, I have a matter in Jasper too. My junior would be here, but only one reply I am giving, occurrency, that is supplementary or additional, as the case may be. That is also from them. So it is, it has evidentiary value. And so far, my lord, yesterday I told that the NRC finality, so I have brought that thing I am giving now because that too I will be in just court. Here it is published as final NRC. Finally, it's the last part of para 3. Eligible for inclusion in final NRC. If anybody has objection, they may go to tribunal. It is also there. So, as I will be in just court, so I am just giving. Worship will go with this and will decide as your worship's desire. Extra to 9 also. 3টা কপি দিচ্ছি। তো যাদের কারণে এটা the top third para, last part, final. It is, if any objection may go to tribunal.
Okay, may I make a mention of item number 17, Lord? Actually, Lordship may not like to take up that matter. Much obliged.
I was in page number 33, man. Page number 33. It is the voter list of 1971, my lord. On the left side of the voter list, it is said Orange. They in their evidence also, and as well as evidence, my lord, WS also, they have said it is an additional, my lord, voter list of 1971. And in this voter list, my lord, who were the voters? The listed voters are Fuljan Nisa, BB, relationship Mafisuddin, Sahera Khatun Bibi, Abdul Subuk, then Abdul Subur, my lord, whom the petitioner is claiming to be the father of the petitioner, my lord. The father name is Akhir Sarkar. Asaruddin, father is Akhir Sarkar, aged about 35 years. Kulsum Bibi, what relationship is Asaruddin, aged about 30 years. Now, my lord, the primary issue here is, my lord, whether this Akhir Sarkar at serial number 3, my lord, 377, Abdul, who is shown to be the father of my lord Abdul Subur, and the voter list of 1966, my lord, page 29, Akhiruddin Sheikh, son of Ali Muddin, is the same in one person or not? That aspect has to be, my lord, seen. Why I'm showing both this list, well, if we compare both this list, my lord, we will not find single person as a voter, common voter in both the voter list.
Page 30.
Page 29 and 33. These are the voter lists which were, my lord, exhibited. The petitioner's case is that, my lord, this Akhiruddin Sheikh of page 29 is the grandfather whose name is wrongly written in page 33 document as Akhir Sarkar. Now, Akhir Sarkar is not a voter here because if he would have been voter in this voter list, my lord, page 33, then his father name, Alimuddin, could have been there. Then we could understand, my lord, yes, it may be the same person. Along with my submission is that, my lord, as the voters of page 29 are not available, not a single person of page 29 is not available in page 33. we cannot assume or presume that, my lord, this Akheruddin Sheikh and Akher Sorkar, who is shown to be father of Abdul Sabur in page 33, is the same in 1%. Because the name is different. Name is different. It is not, earlier it is Akheruddin Sheikh, it is now Akher Sorkar. So that is my point. That is one point, my lord. And in Abdul Quddus, my lord, as I have, my lord, I have relied on that case again and again, my lord. Abdul Quddus said, my lord, these spellings may be accepted. Wrong spellings in 1 and 2 or 2, my lord, the alphabet in a name can be accepted. But in that case, my lord, all the other voters and all the other names of the voter list were, my lord, consistent in the next voter list also. Sirajul Haq, in Sirajul Haq.
Mirajul Haq's case.
Yes, in Sirajul Haq's case. There it was, my lord, the Kefatullah, your lordship knows, Kefatullah become Kematullah. But other, my lord, all other voters were consistent. But here, not a single voter is there. That is my point, number one, my lord. So, another issue, my lord, this voter list of 1971, page 33. Next issue, my lord, you also will find the page 44. This is the link documents, wherever the petitioner is trying to link himself with Abdul Sabar. Page 44. Page 44, my lord, this is the Panchayat certificate issued by the secretary of the Panchayat. The name of the Panchayat is, my lord, number 51, Balatmari Sor Panchayat. First of all, this document is not admissible because of the, my lord, national emblem is embossed in the top of the certificate. Apart from writing the government of Assam, which is not permissible, and which make the document itself inadmissible. Secondly, my lord, this document was issued on 20/06/2025. To describe a fact that she got married on 12/1/1991 to one Sri Quddus Ali. My lord, it is admitted position by them that in 19 they shifted to this Halpukhuri, just before, my lord, 11 years, about 11 years from 2018. So prior to 2000, my lord, if it is 11 years from 2018, it will be something 2006-07, my lord. I accept it 2006-07. But she got married on 12/1/1991. And what is her, my lord, address? If the certificate carries the, my lord, original facts that she got married in 1991, her original address should be there where she was originated, my lord, not the present address. She has given the present address, my lord. You also make see. Sobura Khatun, daughter of Abdul Sobar, Srimati or mother of Srimati so and so of Hela Pakfuri. This is the new village which they have shifted to where they have shifted only during 2008 and 9. 2007-8, as per their admission. And this certificate says Balatmari Gaon Panchayat of so and so, aged about 38 years. She was not aged about 38 years on that time. Was resident with the jurisdiction of the said Gaon Panchayat area. Srimati Sabira Khatun got married on 12/1/1991 to Sri so and so of so and so village. Srimati Sabura Khatun has now migrated from said Gaon Panchayat area to above mentioned location by virtue of marriage, which was solemnized as aforesaid. So this certificate is issued by the present Gaon Panchayat, who has the knowledge only after my lord marriage. Prior to marriage, he has no knowledge. That aspect has to be considered. Secondly, her description, my lord, as resident cannot be held Pakuri during 1991 when she got married. And this Panchayat secretary who deposed before the tribunal, my lord, has in cross-examination what he says. Page 87 is the, my lord, cross-examining evidence of this DW3 Panchayat secretary. Page 87, last part, my lord, cross part. The certificate is issued for NRC updation. This was issued only for NRC updation. The certificate is issued on the basis of the application submitted by the father of the proceeding on dated nil. So it is not that, my lord, he verified. He has issued the certificate only on the basis of application made by the father of the petitioner. There was no inquiry, no verification, and he simply issued that certificate. So if we follow, my lord, generally this certificate of Gaon Panchayat cannot be accepted as a piece of evidence as a proof of citizenship or to prove linkage, even NRC, if the said document is not verified in 2 stages, my lord. Very good. January 72. So, my lord, so, my lord, with regard to the Panchayat certificate, the Honorable Apex Court in Rupjan Begum has clearly said the document can be accepted only if the document is verified in two stages. Number one, the authenticity of the document. Number two, the authenticity of the contents of the document. Those two has to be examined. And the second part, the authenticity of the contents of the document has to be verified. There is a process given that it has to be verified. The later process of verification, that is the authenticity of the contents, will be ascertained after giving an opportunity to the holder. Verification is bound to be an exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of certificate. This is my lord Rupajan Begum, 2018, 1 SCC 579. It is with regard to the Panchayat certificate. Name is Rupajan Begum, my lord. Rupajan Begum versus Union of India. The point of Panchayat certificate, my lord. Para 15 and 16. Para 15, it is said, the certificate issued by the GP Secretary merely acknowledge the shifting of residence of a married woman from one village to another. The said certificate by itself and by no means establish any claim of citizenship of holder of the certificate. That is clear. Then para 16, it is said, even though shifting is to be established, then also, my lord, the certificate has to be verified at two stages. The first is the authenticity of the certificate itself, because whether the certificate is authentic or not, that has to be proved. Then the second is the authenticity of the contents thereof. The latter process of verification is bound to be an exhaustive process. The Gaonbura, the Panchayat Secretary, what process he has taken, initiated, what exhaustive process he followed before writing, before giving the facts there in the certificate. That is not there. Exhaustive process in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. So if it is not there, the certificate cannot be accepted even for the purpose of shifting of the lady due to marriage from one place to another place. And this is only used for that purpose only, not for citizenship. So this certificate, unless the Gaon Panchayat Secretary has followed this process, this certificate, contents of this certificate is not true. Even though he came before the tribunal and stated this certificate is issued by me. Yes, okay. This certificate is the contents. This certificate is my the authenticity of the certificate is proved, but content of the certificate has to be proved by an exhaustive process. That is not. That is one aspect. Earlier, I have submitted my lord again that it is apart from that, it is not admissible because of the national emblem is embossed and the government of Assam is written in the top of the certificate. Then, my lord, the grandfather's name poses doubt. When the my lord DW1 herself stated in page 76, my lord. She said, the name of my grandfather is Akher Sarkar. Akher Sarkar. My grandfather casted vote in the year 1966. Amir Uddin is also the name of my grandfather. This Amir Uddin is nowhere. It is not a fact that Akher Sarkar and Amir Uddin are not the same in one person. So Amir Uddin, Akher Sarkar, Akher Uddin Sheikh. She has not said that my lord Akher Uddin Sheikh and this Amir Akher Sarkar is same in one person. She has said Amir Uddin is also the grandfather, name of the grandfather. If the Panchayat certificate is not there, my lord, then there is no other document to link herself to her projected father. Only evidence is the evidence of the father, oral evidence of the father. So while dealing with this case, my lord, your lordship may only remember, my lord may consider that our reference was at Borkolia, Noskora village under Fakirganj, Dhuburi. So that has also to be seen, my lord, because all other sets of persons are in a different village and different place. And the further
Yes.
and the further, my lord, further's evidence cross parted fees, my lord, 70.
77.
Yes. 84 is the my lord cross part. And 77 from onwards, it is evidence. Is Abdul Sabur, my lord, he described himself as alias A. Sabur, alias Abdul Sabur, son of late Akheruddin Sheikh, Akher Sarkar, Akheruddin, Akher Sarkar, and he is aged about 73 years by religion Islam, by profession. Is resident of Halpakhri. Here he has described his resident of Halpakhri. Now, from the documents exhibited 66, 89, even up to 2005, they have exhibited the document. But he has no document of this village, Al-Pakri, this person. That aspect may also be looked. Your Lordship will see, from the evidence, page 81 onwards, and the evidence of the DW2 further. At para 17, he says, due to erosion of the mighty Brahmaputra, my family shifted from village Manirsar Part 1 to Halpakari under Mondoi PS Lupi. So about 11 years ago. Thereafter, he has given description. He has, my lord, this voter ID card. He has voter list of 2018. But those documents are not exhibited. All other documents prior to that, my lord, since exhibit G, 2005, up to 2005, it is exhibited. So,
Which document you say is not exhibited?
my lord, page para 81. Page 81, my lord. He has given a statement that para 17, my lord. Due to erosion of mighty Brahmaputra, my father shifted from village so-and-so to Halpakari.
Yes,
This
he
is just-
exhibited that 2005.
No,
He's
that is
referring to 2005 as exhibited. Which document you say has not been exhibited?
2005 exhibited, my lord.
Hmm.
From 2018, if we go back 7 years, 11 years, it will be 2006, 7, 8, my lord. They have calculated it properly. 7, 8, after 2005, they have not exhibited any.
After 2005, there's no exhibit.
Yes, but your lordship will find it para 18. Yes, described that my daughter was born so and so, 40 years. Then para 19, he has given a statement, my lord, that he has a voter ID, the father. I'm a regular voter. I have got electoral identity card so and so issued in the Election Commission of India, card number so and so in my name as Abdul Sattar so and so. This is not exhibited. Then again, he has said my
No, even if he exhibits, you will say that there's no value. That
no
doesn't take
value.
us anywhere.
Yes,
No, that
no
doesn't take us
value.
anywhere.
Only what I want to show, my lord. He shifted prior to that, my lord. What suspicion arose, my lord? Prior to that, he exhibited all these documents. After shifting, because this reference is in a different village, and they are saying they shifted just 11 years before 2018, because this affidavit was filed in 2018. and no documents of present release matter, where the reference is initiated. He has recorded in the 2018 voter list also at LAC subdivision Gwalpara, Mornoi village. Halpakari by serial number so and so. Only statement. And there is just a point which I was supposed to point it out, my lord. The main point is, my lord, the DW2, who is claiming to be father of the petitioner, has no other document whereby he could link himself along with the my lord petitioner. Unless there is any documents to link himself with the petitioner, my lord, the oral evidence of DW2 cannot be accepted in case of citizenship. That point is settled by the Honorable Court, and oral evidence alone is not enough unless it is, my lord, corroborated by some documents linking both the father and the daughter, father and the daughter. The Bijoy Das. In Bijoy Das, it is said, my lord, it is settled that no oral evidence will be accepted. 2018 3 GLT 118, my lord. There it is said. Then Asia Khatun, it is also said. Oral evidence of the father. In fact, in that case, father was there. Father will be not accepted unless any linking document is.
Asia Khatun?
Asia Khatun, my lord, it is. This is reported, but I have no. This is WPC number 4020 of 2017. 4020 of 2017. Asia Khatun. Disposed of on 21/11/2019. There it will be para 6, madam. 6 and 7. That's all, madam.
I was referring to the records. In a slip of paper, please give me the cases which you are referring to.
My lord, cases, first of all, my lord, the,
Just write it down in a piece of paper.
yes, yes, I'll write it down and I'll.
Give me a piece of paper.
Yes,
I'll write it down.
I will hand over,
Your senior did not rely on any case citation.
my lord.
Your senior did not rely on any case.
My lord, if a chance will, on Monday, I will give some.
No. You're not keeping it pattern. Mr. M. U. Mahmood, learned counsel for the petitioner, also heard. So for the respondents. Next para. Pursuant to a reference forwarded by the Superintendent of Police within bracket border, Kualpara, bearing reference FT case number 122/10, page 22, dated 29/6/2010, expressing doubt about the nationality of the petitioner, namely, Sobura, Sobura, Khatun, Khatun, wife of Mohammed MD, Kudus, Kuddus, Ali Sikdar, FT case number, capital FT, then bracket, capital G-4, bracket closed, capital M, oblique 327/18, was registered before the member, Foreigners Tribunal, 4th Gwalpara. So, on receipt of notice, the petitioner appeared before the said learned tribunal and filed a written statement. Thereafter, the petitioner has filed her evidence on affidavit, thereby examining herself as DW1, and she had also examined her projected father, Abdul Sabur, ABDUL, Sabur, SABUR, alias A full stop Sabur, SABUR, alias Abdus ABDUS, Abdus Sabur, SABUR, son of late Akhiruddin Sheikh, 77. Akhiruddin, AKHERUDDIN, Akhiruddin Sheikh, SHEIKH, alias Akhir, AKHER, Sharkar, SHARKAR, alias Akhiruddin, AKHERUDDIN, alias Akhir, AKHER, Sarkar, SARKER, as DW2. The petitioner had also examined one Amjad AMJAD, Amjad Hussain, secretary, Guridhap, GURIADHAP, Guridhap, Gaon Panchayat, as DW3. So all the witnesses were cross-examined. Stop. Along with the evidence on affidavit, the petitioner had exhibited the following documents. One could first certified copy of voters list of 1966 within bracket exhibit A, certified copy of voter list of 1971 within bracket exhibit B, certified copy of voter list of 1977 within bracket exhibit C, certified copy of voter list of 1985 within bracket exhibit D, certified copy of voter list of 1989 exhibit E, certified copy of voter list of 1997 exhibit F, voter list of 2005 exhibit G, link certificate issued by the secretary, 51 number, Baladmari, BALADMARI, 4 CHAR, next word Gaon, GAON, next Panchayat. Dated 26/2015, within bracket exhibit H. Certified copy of voter list of 2005, exhibit I. Certified copy of voter list of 2011, exhibit J. Electoral photo identity card within bracket exhibit K. Certified copy of voter list of 2016, exhibit L. Then certified copy of voter list of 2016, exhibit L. Certified copy of voter list of 2018, exhibit M. Final draft of NRC within bracket exhibit N. Full stop. No other documents were exhibited by the petitioner. No, not that. You say, during examination, the said Amjad Hussain, within bracket DW3, had exhibited the certificate issued by him as exhibit W and not and, comma, where exhibit W1 is his signature and W2 is the counter signature of the BDO Matia. Therefore, no other documents are exhibited. Next paragraph. Thereafter, by opinion dated 3/4/2017, the reference was answered in favor of the state and against the petitioner, declaring her to be foreigner of post 25 1971 stream. Next paragraph. The said opinion dated 31/7/2019 has been assailed in this petition filed under Article 226 of the Constitution of India. Next paragraph. The legal counsel for the petitioner has submitted that while deciding the reference, comma, the petitioner had, the learned tribunal had formulated 2 points of reference, comma, which were, number one, you wanted to say anything in reply? Whether, number one, whether the proceedee, Sobura, S-O-B-U-R-A, Sobura Khatun, is the daughter of Abdul Sobur, A-B-D-U-L, S-O-B-U-R, question mark. Number two, if so, comma, whether Abdul Sobur is a citizen of India, having in this regard, comma, having referred to the exhibited documents it was held that it was crystal clear that the petitioner is a daughter of Abdul Sobur, S-O-B-U-R. And accordingly, the said issue was decided in the affirmative. Next paragraph. In respect of issue number 2, as to whether Abdul Sobur is a citizen of India, by referring to the documentary evidence, comma, the documentary evidence were rejected on the ground that the same were laden, LADEN, with gross discrepancies and inconsistency, comma, rendering them as untrustworthy and unbelievable. Stop. Resultantly, comma, it was held that the petitioner had miserably failed to discharge her burden of proof as envisaged under Section 9 of the Foreigners Act of 1946. Accordingly, the learned tribunal had arrived at a definite conclusion that the proceedee, i.e., the petitioner, is not born and brought up through genuine Indian parents in Indian soil. So accordingly, the proceeding, comma, namely, comma, Musamat Sobura, Subura, Khatun, wife of Mohammed Quddus Ali, Kuddus Ali, was held to be a foreigner who has entered the state after 1971. First one.
One very small reply, my lord.
Yes.
Page 75. This is my cross done by the other side. My father's name is Abdul Saur and mother's name is Sahara Khatun. My father is a voter of 71. My father has 7 brothers. My father presently residing at Belapakri. My father shifted to this place from Monisho 10 years ago. The name of my grandfather is Akhir Sarkar. My grandfather casted his vote in the year 1966. Amiruddin is also the name of my grandfather. It is not a fact that Akhir Sarkar and Amiruddin are not the same person. It is not a fact that my father is not a voter of 1971. So there is no contradiction. Now kindly see page 84. This is a cross of my father, page 84. The proceedee is my daughter. I have 1 son and 6 daughters. I am a voter of 71. We are 7 brothers. My father is a voter of 66. My father's name is Akhiruddin Sarkar, alias Akhiruddin Sheikh. There is no any other name of my father. The proceedee was given marriage at Borkalia. So here, daughter says her father is Abdul Sabur. Abdul Sabur says she is my daughter. There is no otherwise cross. So now they cannot say anything more than what they did in the court below, the tribunal below.
Okay. Next to that. It has been submitted that due to minor discrepancies in the names of the father and the projected father and the projected grandfather of the petitioner, comma, the documentary evidence was discarded by the learned tribunal. In this regard, it is further submitted that the petitioner has exhibited voters list of the years 1966 or 1971 1977, 1985, 1989, 1997, 2005, oh five, 2011, 2016, and 2018. Next one. It is further submitted that the petitioner has also exhibited the final draft of NRC in her name. Also, it is also submitted that an FT case was registered against the younger sister of the petitioner, namely, Jamiron, Jamiron, Jamiron Nessa, who has been declared to be not a foreigner by opinion dated 3/4/2017, passed by the learned member of Foreigners Tribunal number 1, Kualpara, in page 89, in so and so. First of all, accordingly, it is submitted that being the member of the same family, while the sister of the petitioner was declared to be not a foreigner, the impugned opinion is unsustainable on facts and in law. First of all, it is specifically submitted that the name of Sid Jamir al-Nasa is disclosed in the opinion dated 3/4/2017. And the petitioner has also disclosed her name. In her written statement, as well as in her evidence on affidavit. First off, it is also submitted that the projected father of the petitioner, namely, Abdul ABDUL, Sabur SABUR, was also examined as DW2. And he had supported the case of the petitioner. Full stop. Next part, it is also submitted that in his written statement, comma, the petitioner has already made a specific statement regarding shifting of his family from village Monirchar, Monirchar, part 1, due to Helapkri, HELAP, to Helapkri, HELAP, KAHRI, under Monai police station in the district of Gwalpara. About 11 years ago. Stop. In reply, comma, it is also submitted that the evidence of the petitioner and his witnesses could not be demolished in the cross-examination of the said 3 witnesses examined by the petitioner. Next para, per contra, comma, the learned standing counsel for the FT matters has submitted that although the petitioner has exhibited various voters lists, but the names appearing in the voter list of 1966 within bracket exhibit A are not common in any other voters list exhibited by the petitioner. So, stop. Accordingly, committee submitted that the issue before the learned tribunal was whether Abdul Sabur, ABDUL, SABUR, whose name appears in the voter list of year 1985. Maybe 1933. What is this of 1979? Then bracket exhibit B. Son of Akher, AKHER, Akher Sarkar, is same as Akheruddin Sheikh, AKH. ERUDDIN, Akheruddin Sheikh. Hmm?
71 maybe.
Like 29 दिखाई से the voters list of 1985. Mr. Pai, I hope I'm dictating it correctly. You are referring to page 33 and you are saying whether Abdul Sabur, page 33, is same as Akhiruddin Sheikh, appearing in page 29. Correct? That's your statement. Full stop. In this regard, it is submitted that the voters, that all the voters of page 29, of the voters list of 1985 are not the voters in the voter list of 1979. Full stop.
Page 33, 1971.
71. Okay. 71. I'm sorry. 71. It will be 71. Thank you for pointing it out. Full stop. In support of his submissions, the standing counsel for the FT and border matters has cited the following cases. Next, para in reply, the learned counsel for the petitioner has submitted that the petitioner and his and her father, who appeared as DW1 and 2, were cross-examined by the prosecution, and the evidence tendered by the said witnesses could not be demolished. That's all. Facts are complete, dictated in these numbers. We may not be able to take up any other matters.
Regarding anomalies in names and address, the Sirajul Haq and Abdul Mutali. Yes, Obla. Yes, I will.